Hey, what up, y'all? I have a clip for y'all. It's entitled "From Long Crime." It's entitled "School Worker Sent Nude Photos to Teen for Months." I don't know what it is with these bad teachers, man. I just don't get it. With that being said, let's get into it.
Until now, game changer. They have a wire trimming head that's universal. It's going to fit any weed eater. They have different size leads on it. They have a 3 and a 6. I went with the 6 because I'm...
In yet another disturbing example of school staff allegedly crossing the line with minors and the legal consequences that follow, we now have a 22-year-old New York school worker who's facing charges after investigators say she sent explicit photos of herself to a 14-year-old boy. We're going to break it all down with former sex crimes prosecutor Rena Paul. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. We have this 22-year-old New York school employee, maybe former school employee is more accurate, and she is facing some very serious charges after authorities say she sent nude photographs of herself to a teenage boy over a period of 3 months. The Chemung County Sheriff's Office announced the arrest of Anna Maria Malazzo of Elmira on June 16th. This is following an investigation into allegations that she had shared sexually explicit images with a 14-year-old boy. And this all began back on June 9th. According to the official release from the Chemung County Sheriff, it says, a school resource officer assigned to the Greater Southern Tier BOCES, that's an educational governing body that serves 21 school districts in the state of New York, it received a complaint alleging Malazzo sent indecent material to a minor. Goes on to say the Chemung County Sheriff's Office Criminal Investigations Division assisted with the investigation. During the
I'll be right
investigation,
back
the
in a
criminal
second.
division learned that over a 3-month period, Malazzo sent nude photographs of herself to a 14-year-old male. As a result of the investigation, Malazzo was arrested for disseminating indecent material to minors in the second degree and endangering the welfare of a child. Now, according to New York state law, disseminating indecent materials to minors in the second degree, that is regarded as a Class E felony, and endangering the welfare of a child, that is regarded as a Class A misdemeanor. So rather than being held in custody, Malazzo was actually issued an appearance ticket. She's expected to face charges in Wellsburg Court at a later date. But meanwhile, the Greater Southern Tier BOCES confirmed to NBC affiliate WETM that Malazzo has been terminated from her position. Though, to be clear, officials didn't really disclose her specific role within the school system. That's why we're calling her a school employee. And the outlet reported that she had previously worked at a BOCES facility in Chemung County. By the way, the identity of that 14-year-old boy has not been released. It remains
Good.
unclear whether he was even a student at the school
His name
where
don't need to
Malazzo
be
was employed,
released.
but disturbing allegations, to say the least. And as the case moves forward, the charges against Malazzo, this highlights something we've been covering a lot here on Sidebar. It highlights the serious legal consequences of alleged or confirmed inappropriate communication between adults and minors, particularly
Talk about it.
within educational settings. Again, we have talked about this consistently and constantly here at Law and Crime. We're trying to figure out why is stuff like this happening. Now, to break this down, I want to bring on former sex crimes prosecutor and former federal prosecutor Rena Paul. Rena, thank you so much for coming on. Really appreciate you taking the time.
Thanks for having me.
So when you look at a case like this, what are the elements that prosecutors need to prove to, let's say, secure a conviction for disseminating indecent material to minors in the second degree under New York law? What are we talking about there, if you know?
When we talk about elements, we talk about what evidence we need to gather as a prosecutor to support a charge, right? So here, when you read through the law of disseminating indecent material, the prosecutor will have to prove first that the child was under 17. That should be pretty straightforward. That the material was indecent, which means that it contained nudity or sexual conduct or sadomasochistic abuse, which doesn't seem to be part of the allegations here. Here it seems to be nudity, so they'll have to demonstrate that. Evidence there, we're talking about the photograph itself, presumably a copy of that photograph or some version of that was given over by witnesses, and and this is the more amorphous part of the elements, that it was harmful to minors, meaning that the quality of the description or
Damn, I
representation
forgot my
in whatever
water.
form was appeals to the, they call it prurient interests of minors, is patently offensive to prevailing standards in the adult community as a whole with respect to what is suitable material for minors, and considered as a whole lacks serious literary, artistic, political, and scientific value for minors.
Hey everybody, this is another law and crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease? And the research is potentially linking ultra-processed foods to all this? Yeah, well, Morgan & Morgan, they're stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they are ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. Let me ask you this. Is there any explanation, is there any defense to it? Let's say she really did send the materials. I think it's going to be difficult for a defense attorney to say she didn't send them, right? They could say, oh, well, someone else had access to the phone, maybe, sent the photos. Again, I have no idea. This we have limited information, but assuming that's not a defense, is there any kind of benign reason for sending photos of a body part? I don't know what was exactly shown, but have you seen a defense in some way to say there was an innocent explanation for this?
This comes up, the question of what, it comes up in particular with regard to child pornography cases, of what the definitionally it means when you're looking at an image. Here, the standard's a little different because it's about just nudity is part of it. So what is nudity there, and what part of the body needs to be shown is something that will be looked at. And yeah, if there would be an arm, if we're talking about an arm or another nude part of the body that is not something that fits the definition that could potentially be harmful for minors, potentially a defense.
Is there any chance that this could be a federal charge of some kind?
It's hard to know on what we know very little right now.
Right.
So it's hard to know exactly what is on the, first of all, how this was disseminated. I mean, we know that generally there are a lot of charges involving minors on social media. I have investigated many cases involving social media transfer of images. It can also be a phone. It can also be an email. You mentioned that we don't know who this child was in relationship to the accused. We don't know if this was a person who was with her at school, so that there was some reason that they have each other's contact information, or was this over social media incidentally? Did she know that this was a minor? These are the questions. But in terms of federal charges, we'll see. I mean, we need a little.
If it crossed state lines, maybe, if the communications crossed state lines, would that be enough?
When we talk about cyber cases, yeah, federal charges are always kind of percolating, because we're talking crossing state lines is something that we use as a big picture way to talk about federal charges. But yes, when we're talking about things in cyberspace, often they cross state lines, right? It's the internet. So yes, it's possible that there could be a federal charge, but we need to know more about how the dissemination took place.
And if these allegations are true, I ask this all the time, but the fact that she was a school employee, although the exact role is not clear, that takes it to a different level, right? Sometimes states actually have laws that specifically say if you're dealing with a student or you're dealing with, if you're dealing with a student-teacher relationship, it's specifically built into a criminal statute. Here we don't know if she was his student or whatnot, but the fact that she worked at a school, doesn't that take this to a different degree? If these allegations are true, doesn't it make it even more insidious?
Well, it's when we think about positions of trust and the way that people who wish to harm children get access to kids, one of the biggest misconceptions is that child abuse happens by strangers often. It's usually not the case. What I have seen in my experience is that usually when there are charges, it's people who are known to each other. And how do you become known to a child? Usually you become known to a child because you have access to that child in some way. A school setting is one way to access a child. And we think about grooming, right? We talk a lot about grooming in this arena, about how adults become close to children and get the opportunity to do things like send inappropriate material or hands-on abuse. And we think about the way in a school setting that the school itself trains its employees to work with children.
Yeah, and is there any way that schools can protect themselves from this? I mean, you don't have a crystal ball, but you have to imagine during the hiring process, could there have been a red flag? Maybe not. Are schools in a situation, or parents in a situation where you really are going into the wild? You just don't know. You can't prevent something like this. Again, assuming these allegations are true.
As someone who works with schools in this capacity, I mean, you want to create a culture of reporting. There's no way to predict what's going to happen all the time. We can't eliminate all risk, is what I always tell clients. It's not possible to eliminate all risk. We think about background checks sometimes, and could that bring something up? For sure, if there's a prior incident and a background check would show that incident, that's a great way to predict future behavior. But otherwise, we have to work as a school or an organization to create the conditions,
not just work with the teachers, but work with the
be in a position to see when things are
parents
not
as
feeling right with
well.
their coworkers, and also to inform students of their rights and the way that they can identify something that might be going wrong.
That's the importance of a school resource officer, having somebody there as well, right?
It's great to have dedicated staff.
Why don't we have more information about her and her case? Why don't we know exactly her role? Why don't we know more details? Is it just too early? Will we learn that as time goes on? Will we learn that during a preliminary hearing? Something like that?
I assume at some point the actual charging document will come out, and then we will be able to read the charging document and see what's alleged by the prosecution.
Is there a chance that she could be hit with additional charges? I mean, how many times do we see a situation where there is an arrest and then more people come forward? Now, I'm not saying that's the case here. Right now, all the evidence seems to suggest there is one alleged victim, but you wouldn't be surprised if you see an upgrading of charges, or even with respect to this one alleged victim, if we find out more things might have happened, right? Again, we're assuming, but we don't know.
It depends where they are in the investigation as the prosecutors. If they're early in the investigations are multifaceted when you're talking about cyber. Sometimes when you investigate a cyber case, you arrive at all the material right away. You find the phone, you look through the phone, let's say, and here's what we have, we know what we have. If we're talking about social media or disappearing apps, things that move, the investigation of such a crime or an incident is more difficult because you're finding material that could be gone or in different places, and so it could be kind of an evolving investigation that could lead to more information down the road.
Don't get me wrong, I love a big soft light, but this thing took up my entire room. I recently discovered LumeCube's Edge Light.
Lead to more information down the road.
You think in a case like this, they would push for a plea deal? And I wonder what certain factors are being considered here. She's 22 years old, still an adult, right? But does her age factor into this? Does the fact that you're talking about a misdemeanor and a Class E felony, does that influence prosecutors to say, hey, let's make sure we don't take this to trial? Maybe we don't want to have this alleged victim testify. What would a plea deal look like? What are you going to be looking out for?
Talking about plea negotiations involving children, one of the things that prosecutors do consider often is having the potentially additionally traumatizing possibility of the victim testifying again. So certainly when weighing all of the considerations, I think that's something that prosecutors do look at. It doesn't carry the day all the time, but they look at it. Also, the past history of the offender, the the possibility and the strength of the case, whether or not that the evidence is really very confidently shows what the prosecutor is charging, or whether or not there are some issues with the evidence. These are some of the things that prosecutors do consider when they think about plea deals.
Whether it's a plea deal or she's found guilty, would she have to be put on the registry?
Well, a plea deal, potentially with a plea deal, we have to think about what she's going to be pleading to. When we think about plea deals, sometimes they are to the charges that are charged, right? So sometimes it is what we see already in the charging instrument. Other times there's pleas to different charges. So depending on the charges, yeah, if there is a plea to a charge with a sexual element, we're thinking about the registry.
Now, as we're talking about this case, and I mentioned we cover so many of these all the time, I want to talk about another very high-profile case that we have been covering here at Law and Crime. It's the case of Christina Formella. So this is the suburban Chicago special education teacher who is now facing dozens of felony charges after authorities say she allegedly sexually abused a 15-year-old student, grooming him for years before engaging in a months-long inappropriate relationship that included encounters at school, in her home, even during class hours. She was arrested back on March 16th after the mother of the alleged victim discovered all these disturbing text messages between her son and the married teacher. According to prosecutors, the alleged grooming began when the boy was just 14 years old, with Formella allegedly assaulting him during a tutoring session back in December of 2023. Now, Rena, I want to talk about this and how it compares to the other case involving Milazzo. What is the legal significance? What does it hold when you have alleged abuse taking place, allegedly, again, during school hours, on the school property? That, again, it feels like a different level.
We're talking about 55, I believe, right, felony counts. So this is a far more, in terms of the felony degree, this is a much higher charge than the single count of disseminating indecent material, which is an E felony. This case seems to be about, according to prosecutors, hands-on conduct as opposed to the dissemination of just material, which changes the specter.
Yeah, so she was initially charged with 2 counts of aggravated criminal sexual abuse, 1 count of criminal sexual assault, but during a June court hearing, prosecutors revealed shocking new details that she allegedly had sex with this student or engaged in sex acts with this student 45 times in various locations, again, including on school grounds, in her own home. She's since resigned from her teaching position. She's surrendered her license. She's now facing 52 additional felony charges, 55 in all, but this includes multiple counts of aggravated criminal sexual abuse, grooming, indecent solicitation, criminal sexual assault. If she's convicted, she's looking at up to 60 years in prison. This is according to people in the Chicago Tribune. By the way, when you hear a charge of grooming or an allegation of grooming, how do you prove that, Rena?
There are different statutes in different states. Right. So when we, again, back to talking about elements, when we think about proving an actual charge, we have to review the elements in the state of the actual crime. Generally, when we're talking about grooming, the idea of grooming is creating a relationship of trust and emotional connection to manipulate and exploit a child. This is a tactic used by abusers to build that relationship, to get the access. And like many things in the law, when we're talking about something that is an amorphous standard, a vague standard, grooming, it's not like, let's say, theft, right? Theft is stealing from another person. That's a pretty straightforward thing. Did that happen or did that not happen? It's different when we're talking about emotional manipulation or, and in the world of sexual misconduct, that is what we're talking about a lot. Consent, emotional manipulation, things that occur in the minds of the people that we're talking about. So
at Granger, we're for the ones who pay attention to every little detail, the ones who fuss, tinker, and sweat the small stuff. Because you know the tiniest thing can make the biggest difference when it comes to keeping business moving. We get it. We're the same way, offering access to product experts to help you quickly and easily find what you need. So whatever your industry, you know you're always getting professional grade products. Call, click Granger.com, or just stop. It's 2:00 a.m. Hi, Granger, for the ones who get it done.
About. So when we're thinking about grooming, we want to look to the behavior of what's happening. We want to look at the evidence that supports that, the possibility of that attempt to make that relationship stronger and to get that access.
Why hit her with so many charges? Does that make sense? Is it for every single individual episode? Is it unusual to charge her with 55 crimes?
I would imagine that it relates to the different acts, alleged abuse, right? So rather than charging one, you go charge each time that it happened. It's not unusual to charge multiple acts of violence or sexual misconduct when there are multiple acts against one person. That's not unusual. 55 is certainly a lot. I wonder how they will be breaking that down and how each one will fare, because if you think about the trial, each of those counts has to be proved. And when a jury is listening to 55 counts, they have to keep straight for them what's what and what evidence applies to what charge. And that's something that the prosecutor needs to be mindful of in trying a case like that.
Could that help the defense, though? More counts, more opportunity to raise reasonable doubt. If we show a weakness in some of the counts, it may expose weaknesses in the overall case?
Possibly. It's more to investigate, more to present contrary evidence to, more potentially cross-examination of witnesses, depending on who's going to be testifying to each. I don't know if this testimony, the anticipated testimony, will be just of the alleged victim, or will it be other people who have had some sort of access, who have seen things, or it depends. So there is opportunity for a defense attorney to question each of those counts, to interrogate each of the evidence for each of those counts. It certainly gives them more opportunity to do that.
Would you say prosecutions of these kinds of cases, whether it's the Milazzo case, the Flamella case, or any of the other ones we cover on Law and Crime in the last 15, 20 years, it's generally proven through digital evidence, text messages, photos, personal notes, voice notes? It seems to me, so many of the cases that we cover, the digital trail, it reveals so much, and also makes you wonder, if they knew this was a crime, if they knew they're trying to keep this hidden, why do they create such a digital footprint? Am I wrong about that, or is it the digital evidence that seals a lot of the fate of these people?
Cases that involve the testimony of children are cases in which prosecutors tend to try to support as much as possible with additional physical evidence. Digital evidence is very probative evidence. It's evidence that is hard to controvert when you're faced with it as a defendant in a criminal case, right? So the truth is usually of sexual encounters is that there are usually just two people involved. The one that is being charged being one of them, and the one who is making the report being the second. When you have digital evidence of those relationships, that is something that can give a window into the mental state of the actors. What were they thinking? And that is helpful evidence when trying to prove a intimate situation, a sexual situation, a situation where there's no other witnesses.
Right. And maybe as opposed to the Milazzo case, when I said that the reporting indicates she's facing up to 60 years in prison, so if that's maybe the rest of her life, is that something that you would expect if all these allegations are true?
That's the maximum, I assume, counts if each of those counts were to be proved or to be pled to. Yes.
Yeah. And look, she's right now free on bond. She's banned from contacting minors or entering the high school where she once worked. By the way, are you surprised that she's free on bond?
No, it's not. Bond is a different consideration than conviction and the strength of the evidence. I think that, bond is a question of whether there's a flight risk and
right.
Whether or not we think that the judge makes a determination whether the person will return to court. So it's a different calculus, and it's different in different states, different in federal, in terms of the way that they weigh that consideration. So no, I'm not surprised.
And to be clear, once more, even though these allegations are heinous, even though prosecutors may have significant evidence, She is innocent until proven guilty. Want to make that clear. Same thing for Miss Milazzo. We will keep a careful eye on both of these cases. These are developing stories, so be sure to check out Law and Crime's past coverage on this case, on the Formella case, on our Law and Crime YouTube channel, and we'll make sure to
All right.
continue.